What if you pass away without a will? So, if you pass away with no will in place, state law kind of fills in the gaps for you. And it dictates who would get what if you haven't clarified it in a will. And it says who your heirs and beneficiaries are. So it tends to follow kind of what you might expect most people would choose. A surviving spouse is the primary heir, and then children after that. If there's no surviving spouse, or no children that are living, then it goes up to parents. They would receive the estate. And then ultimately, if parents are passed away, it would come to siblings, nieces, and nephews until someone's available to receive the estate. But it can get tricky. If you have a blended family, or if either you or your surviving spouse have children from a different relationship, because then the numbers get a little tricky. They don't just go flat out 100% or in equal shares in that case. So, even though Michigan law does fill those gaps to make sure people that are close to you receive your estate, it might be different than what you would want. And it also doesn't clarify who's in charge of the assets. What if there's a minor who handles those funds, or an incapacitated beneficiary? So state law really is just following your family tree, but it doesn't do a whole lot more than that to make sure that those that do receive your estate receive it in a way that you'd want. So maybe you'd want specific ages along the way, especially for a minor. And if you die without a will, state law does fill in those gaps. But even then, it's really important to make sure that your plan is laid out in writing, so we're not having to rely on state law for you.